Hello again. In this session, this is the fourth session of competing interests, and I want to cover some subjects that are as important as everything else we've covered. Creditor versus debtor. Section 523 in the Bankruptcy Code covers a number of types of debts that are not going to be discharged in bankruptcy. Let me give you an example. Let's say a year before you filed bankruptcy, you went into the bank and you borrowed $25,000. And the banker told you, well, I need a financial statement. So when you filled out the financial statement, you substantially overstated the value of your assets. Maybe you even listed some assets you don't even own. And then on the liabilities, you didn't list all the debts that you owe, or you didn't list the proper amounts. So the banker in bankruptcy is going to say, well, I only loaned him that money in reliance upon that financial statement, and it was reasonable for me to rely upon the financial statement. So he's going to argue in bankruptcy that, yeah, your bankruptcy can go through, all your debts will be discharged, except the debt that you owe to him. He's going to want that debt to be non-dischargeable. Well, that's a Section 523 action. That's an adversary action. That will be a trial in the bankruptcy court. 727, Section 727, that's a different kind of a lawsuit. Let's say that you've got a debtor or creditor, and that creditor is he's mad that you filed bankruptcy. So he can't find anything wrong with the debt you owe to him, but he's going to look at your bankruptcy petition and try to prove that you concealed assets or otherwise filed a false financial posture in your bankruptcy petition. In a 727 action, he's going to ask that your entire bankruptcy petition be dismissed. So everything you've done, filing your petition, the attorney fees, all the work, your bankruptcy petition is going to be dismissed, and the judge will rule that forever and ever those debts are non-dischargeable. Those are adversary actions in the bankruptcy court. Now, what do you need to know about adversary actions? One thing you need to know is when you sign an attorney contract with me or any other attorney, there'll be a paragraph in there, and it will explain to you, if it's explained to you before you're hurriedly told to sign it, that your attorney fee does not include adversary actions. If your attorney has to defend you in an adversary action, he's going to charge you on an hourly rate. I mention it to my clients. I want to cover it. I don't think a lot of attorneys do, unfortunately. You need to understand that when an attorney deals with a client, we do not owe the client a contractual duty. We owe what the law calls a fiduciary duty. I am required to bring up matters to you that I think you should know about, even if you don't ask about it. Well, I think telling you about adversary proceedings is that important. So you need to know that about adversary proceedings. Adversary proceedings can also include, let's say that during the 90 days before bankruptcy, you knew you were going to file bankruptcy. So you went out and bought a gold watch on a credit card, or a necklace, or some type of jewelry, something that was a luxury item. If you did that within the 90 days prior to bankruptcy, then that debt's not going to be dischargeable. And that particular creditor will probably file a 523 adversary action saying, hey, my debt should not be discharged. This guy bought luxury goods during the 90 days prior to bankruptcy. There's a $600 limit on that. Again, it doesn't come up very often. 99% of all debtors are honest. There's a second part of the rule that if you got cash advances within the 70 days prior to bankruptcy filing date of $750 or more, then that debt is not going to be dischargeable. The third part of the rule is even more encompassing. Let's say even 3 years prior to your bankruptcy, you racked up a bunch of credit card debt. and you knew at the time that you were never going to pay that credit card debt. Those are rare cases, by the way. They're not going to come up very often, but in the rare circumstances that they do, then those debts are not going to be dischargeable. There are other kinds of adversary actions that will not involve you. It'll be two creditors arguing about who's got a first or a second mortgage position on a property. Those are adversary proceedings. They'll be in your bankruptcy, but they really won't directly concern you. The other part that I want you to know about is, let's move up here on right here. Let's say that you meet the technical requirements for doing a bankruptcy, but anybody that informed about the case, they know that you're trying to be a sneaky Pete. They know that maybe you've made $100,000 a year. You could have paid your creditors, but you haven't. Those, again, are rare cases, but the bankruptcy judge at all times has the power to dismiss a case for abuse. They don't do it very often, but sometimes they have to because the circumstances warrant that. Bankruptcy judges, while we're talking about that, bankruptcy judges have a real illustrious history. They're called courts of equity. If you've ever studied the history of law, equity comes from the word horseman. A good horseman will tilt neither to the left nor to the right, but he'll ride upright. In other words, he's going to be fair to everybody. Well, the purpose of the bankruptcy code is to give you a fresh start. So if there's any doubt about something, the judge is going to rule in your favor. But on the other hand, if there's evidence that you've abused the bankruptcy code or you haven't been honest, then your petition is going to be dismissed. Now, again, none of those problems like that come up very often in consumer bankruptcies. A lot of the dishonesty, as we all know, is in corporate bankruptcies, Enron and the likes of those fellows. So they don't apply to consumer bankruptcies. In adversary proceedings for consumer bankruptcies, I would say maybe, gosh, I don't know, 2% of all the cases involve an adversary proceeding. Let me give you one last example that will give you and should give you a good deal of assurance about adversary proceedings. Let's say that you have a disgruntled creditor, and he's mad that you filed bankruptcy. So he's got plenty of money, and he's going to hire a lawyer, and he's going to file a 523 or 727 action against you. Well, if the bankruptcy judge rules that he was completely without a reasonable basis for accusing you of something of a wrongful nature, then the judge is going to make him pay for all your attorney fees. As a result of that, most informed creditors are never even going to think about filing a 523 or 727 adversary action. The facts are going to have to be very clear-cut that you did something of a wrongful character. Secondly, you need to understand that you making a mistake in your bankruptcy petition, that's not going to result in it being dismissed. Frankly, there are a lot of attorneys that don't take the time to work with their clients and prepare the bankruptcy petition properly. There's clients that don't understand something. So the judges recognize a distinction between you making a mistake and you trying to conceal something. If you just made an honest mistake, there's not going to be any adverse consequences. Lastly, let me say this. I hope that you will take the time to watch these 4 videos again on competing interests. You've learned a lot. This is a lot of information. I don't want you to memorize anything. I want you to understand it. And I think if you watch these videos twice, you will understand it. You know that old saying, repetition is the mother of learning. Go through these again. You're not going to memorize anything, but you'll be able to pull up effortlessly what you need to know about who are the competing interests in your bankruptcy. Who are the players, so to speak. So watch it again and profit from it. I want you to understand your bankruptcy. You're getting a fresh start in your bankruptcy, and your fresh start will be greatly enriched if you understand the bankruptcy process. You're not going to be stressed as you go through the bankruptcy process. You're going to understand what's going on. That will give you confidence. And you deserve that. Every client deserves that. I wish I could teach this to every client that goes through bankruptcy. Thank you.